relax. Hopefully, you're in a cool place. And we are going to get started. So, welcome to the June legal update. Hang on one second. I just want to get my screen started here for you. Okay, so again, welcome to the LIBOR June 2025 legal update. Before I do get started with substance, I just want to, for those of you who have not taken a class with me, I want to just kind of direct you to something that I think is really helpful for you to stay updated, and that's LIBOR's website and LIBOR itself. I'm going to go through a lot of changes. I'd say more than half, maybe 2/3 of this material are things that weren't covered last month. And that is because everything in this industry, especially with the law, is always changing. So you really need to have a system that allows you to stay on top of those changes. And I think one of the major benefits you get for being a LIBOR member is we give you that system. So I am going to say, take this class every month or every 2 months or 3 months, just so you are aware of changes that are happening. Visit our website regularly, lirealtor.com. Look at the Thursday morning email that you get. It's got a ton of information, including a lot of a weekly legal tip that covers a lot of what I'm going to cover today. And a lot of the events that we have, free events or low-cost events, really keep you informed. They're great networking opportunities, but really what we strive to do is just keep you informed. Make you aware of the changes. If you're a broker, you're an office manager, we give you a ton of materials to help keep you organized, keep your office organized, and keep your staff updated. So go to the website, check it out, go there regularly, make it part of your process, make it part of your system. Again, lirealtor.com is where the website is. As far as legal goes, our legal tips every week, our documents on demand, which has all of your forms, our dispute resolution center. Please take advantage of the benefits that we offer through professional standards. I know a lot of you're familiar with the code of ethics and ethics complaints, and arbitration, but there's other aspects to that department. We have a free ombudsman program. What is that? If you've got a dispute with another realtor, an issue with another realtor that you just need someone to help straighten things out, communicate, bridge the gap in terms of communication, we have a free service that does that avoids you getting in the situation where you need to file an ethics complaint, potentially solves a compensation issue so you don't have to engage in arbitration. It's worth a shot. Give our professional standards office a call, visit the website. Again, it's a free service, so really there's no point in not giving it a shot if you're having that kind of issue. And again, just a lot of education materials that we offer for you and your clients. Last thing before I get into substance, remember, LIBOR has its own legal support center now. So you do have access to the NYSAR helpline, but we also have an additional helpline that you can reach out to. It's staffed by a qualified attorney, 9 to 5, Monday through Friday. Just call the main LIBOR number, 631-661-4800. It's extension 335. The attorney can provide you information, general information on real estate matters. So I'd like to start this class in terms of substance by saying, well, what are all of you asking? What are you calling into the Legal Support Center? What are the most relevant questions or most asked questions of the month? So one thing I know we've gotten a lot of calls on are can the listing broker advertise or take credit that they're the buyer's agent in the MLS or elsewhere when the buyer is unrepresented? The answer is no. When a buyer is unrepresented, the listing agent is not working as a buyer's agent. The listing broker is representing the seller and the seller's best interest. You are not assisting the buyer in any way that's not in the best interest of the seller. Yes, you're interacting with the buyer, but you're interacting on behalf of the seller and working in the seller's best interests. And you better be providing an agency disclosure that explains that. You are not working for the buyer, and you are not the buyer's agent. So you should not be advertising yourself as the buyer's agent when a buyer's unrepresented. You're running into agency issues, advertising misrepresentation issues. So do not take credit as being a buyer's agent when the buyer is unrepresented. I see a question in the chat about the FAIR Act. I will get there. I promise. Lots to cover on the FAIR Act. In fact, that had been the #1 topic in terms of questions. I'm going to devote an entire separate section to the FAIR Act. So what forms, as far as an unrepresented buyer, let's say someone shows up unrepresented to an open house, calls you about a listing. What do you do? Well, at first substantive contact with an unrepresented buyer, and prior to entering into any negotiation. So if that unrepresented buyer starts asking you about making an offer, price, and terms, you are going to provide an agency disclosure and the New York State Housing and Anti-Discrimination Disclosure Form. The agency disclosure has to inform the buyer you're working in the best interest of the seller as the seller's agent. Ultimately, you're also going to provide a lead paint disclosure signed by the seller, written acknowledgement that you inform the buyer of their right to receive the property condition disclosure statement prior to signing a contract. Totally different topic, but I'm an agent moving to a new firm. Can I take my listings with me? This question comes up almost every month. The answer is no. In New York, the broker, not the agent, owns the listing. All right. A seller is the client of the broker, not the affiliated licensee, not the team, not the agent. The broker owns the listings. So unless there's a formal agreement with the broker to modify this, an agent cannot take their listings when they leave their brokerage. This includes even if a salesperson ultimately gets their broker's license, sets up their own brokerage, they cannot just take the listings with them, right? The existing broker who has that listing owns the listing. So if a licensee enters a new listing agreement with a seller, knowing that seller already had a listing with the former broker, an active listing, that's illegal. That could subject that licensee to discipline by the Department of State. All right. Before we get to the FAIR Act, this question's come up. So what fees can a landlord charge in New York State? We're talking about the state generally, not just New York City. Right now, just New York State law. So this would apply throughout the state, including the counties, Long Island. What can a landlord charge? So there was a law that was passed back in 2019. It's called the Tenant Protection Act, New York State Housing Stability and Tenant Protection Act. And it provides anywhere in the state, the landlord can only charge 1 month rent for security and 1 month advanced rent. So first month's rent and 1 month security. Landlords in New York State, across the state, this is not just New York City, that is what they can charge, period. They cannot charge more than that. The landlord cannot collect an application fee and cannot charge more than a total of $20 for a background or credit check fee. That's it. This is not the FAIR Act. This is statewide. The fee has to be waived if the applicant provides their own background or credit check within the last 30 days. Also note, if the landlord does collect a fee for a background check, they have to provide a copy of that report to the tenant, along with an invoice or receipt from the company that conducted that background or credit check. So this is really important. This is statewide. This is not just New York City. It's been the law for about 6 years. Please make sure you're aware of it. If you're advertising listings and that ask for anything more than this, it can be a licensure issue. Department of State can fine you. So please make sure you're aware of that when it comes to rentals. All right, so we are going to talk about the FAIR Act. Before I do that, I see a couple of questions about, I guess, about the issue about if an agent takes their listings with them. Well, an agent can't just, somebody asked, sometimes if an agent withdraws the listing and relist the property with their new, I guess, their new office, is that legal? The agent cannot just withdraw a listing on their own. It would have to be with the broker's approval. If the original broker releases that listing, that's fine. But again, an agent can't withdraw a listing on their own. The broker and the owner have a contract. It's between the broker and the owner. The broker owns the rights to that contract, not the individual agent. So unless a broker releases that listing to the agent, or the owner and the broker agree to a release, the agent cannot take the listing. Another question, and I'll answer one more in terms of these, and then we'll move on. But I see a question about an unrepresented buyer. Can a buyer and seller sign a dual agency agreement? Well, there's no such thing as a dual agency agreement, but if let's just say a seller has authorized the listing broker to engage in dual agency or dual agency, which is with a designated agent, and they have the informed consent of the seller to do that, and a buyer then asks to be represented by the listing broker, and the buyer is made aware of the consequences of that, the risks of dual agency, and provides their informed consent to operate as a dual agent or a dual agency with designated sales agent, that is permitted. In that case, the listing broker, if it's done with the informed consent of both parties, you have not only a listing agreement with the owner, but a buyer representation agreement with the buyer. In that case, yes, then the listing broker could claim that they are the buyer's agent as well, because they are operating as a dual agent. All right, so I'll take additional questions on some of these topics. I just want to move on to some of the other material. And the thing I want to talk about now is the New York City FAIR Act. So first, what is the FAIR Act? It applies only in New York City rentals. Believe it or not, we had a question to the Legal Support Center last week asking, are Nassau and Suffolk part of New York City? No, they are not. It's the 5 boroughs that this applies to. So any residential rental in the 5 boroughs is impacted by the FAIR Act. And the FAIR Act is New York City's Fairness in Apartment Rental Expenses. Again, it's New York City only. There could, at some point in the future, be a statewide law that says the same thing. But right now, this is only New York City residential rentals. And the act does a couple things, but the major thing is it prohibits landlords from passing their broker fee on to prospective tenants. There were lawsuits that tried to stop the FAIR Act from going into effect. Rebney and NYSAR had filed suits to stop the FAIR Act. The state, the governor, actually filed a brief in that lawsuit and said, well, we support the law. And that's why I say maybe long term, or even in the short term, this could happen at the state level, because the state said, we support the law. We don't see any issue with it. So there was a court decision on June 10th. The court said the law can go into effect. The effective date was June 11th. The court denied the injunction, which was an attempt to stop the law from going into effect. It dismissed many of the claims. So the FAIR Act is now in effect. And again, it's only residential rentals and leases in New York City. It went into effect June 11th. And it does not apply to the rest of New York State. So here's the language right from the law. What does it say about broker fees? And I'm just going to point to the 2 paragraphs here. It says a landlord's agent shall not impose any fee on or collect any fee from a tenant related to the rental of residential real property. Two, any agent who publishes a listing for a rental of residential real property with the permission of authorization of the landlord for such property shall not impose any fee on or collect any fee from a tenant related to the rental of such property. You're like, Patrick, why are you keep harping on any fee? Because there's no workarounds, all right? Any fee means anything, right? If you are the landlord's agent, you cannot impose any kind of broker fee, kind of creative workaround. You can't do it. If you work for the landlord and you have the listing, the landlord has to pay your fee. You can't pass it around or pass it off to the tenant with some kind of creative way. I've got that image there. No, the handout. You, landlord's agent, can't collect or impose any fee on tenants, period. Landlord's agents have to have their compensation agreement with and receive their fees from the landlord. So if you have any pending or active agreements on rentals with landlords, make sure that that's what your agreement says. You cannot, in New York City now, have an agreement with the landlord that says the tenant will pay the broker fee for listing the property. Brokers agents, brokers marketing an open listing, you're also prohibited from collecting a fee from the tenant. I'll get to it in a minute. Unless you are working for the tenant under a tenant representation agreement and providing services to the tenant, that is the only way a broker can collect from the tenant. Any other kind of sort of creative workaround is not allowed. If you are listing a property on behalf of or working for the landlord, you cannot collect a fee from the tenant. Co-broke restrictions. Tenant's agent can't kick money back or share their compensation with a landlord's agent. It's the same thing. It would just be basically a pass-through. So tenants' agents cannot share their compensation with a landlord's agent. Tenants' agents. Brokers can collect fees from a tenant if they're hired by and acting in the interest of the tenant. So if that's the case, you should have a written agreement with the tenant. It can be exclusive, it can be non-exclusive. You should explain, I am working for you as a tenant's broker. Here are the services I'm providing for you in terms of helping you find a rental. And it should specify what the fee is. You should be providing an agency disclosure, explaining to that tenant that you are working as a tenant's agent. That is the only way you should be getting paid by a tenant. So dual agency, I see a bunch of questions pop up on this. Reason I didn't answer them is because I'm getting to it. So dual agency is allowed, and I have a but. So landlord still has to pay their agent. Landlord's fee can't be paid by the tenant. So you can't say, I'm a dual agent, tenant's going to pick up both sides of the transaction. No. Whatever you've agreed to with the landlord must be paid by the landlord. If there's a separate agreement with the tenant and you have authorized dual agency, the tenant can pay that fee for the services you're providing. So if the brokers paid separate fees by both the landlord and the tenant for the separate services provided to each, you also need consent from both parties to be paid by the other. So basically, you would have informed consent, you've explained dual agency, you've provided agency disclosures, you've got the consent to operate as a dual agent. You would have your listing agreement with your landlord. You have to be paid whatever that fee is by the landlord. You would then have a tenant representation agreement with the tenant. That agreement would specify what the tenant's paying you for the work that you've done for the tenant. And you'd have to have consent from both the landlord and the tenant to receive the respective fee from the other party. I'll go over that more if there's questions at the end, but it's hopefully that's pretty clear about the process that you would need to follow. There are also fee disclosure requirements under the FAIR Act. So listings must clearly disclose any tenant fees, any advertisement. You have to disclose what tenant fees there are. Before signing the lease, landlords or their agents must also provide the tenant an itemized written disclosure of all fees and include a short description of each fee. And that disclosure has to be signed by the tenant prior to signing a lease. It needs to be retained for 3 years, and a copy has to be given to the tenant. I see a question here about landlord must pay listing agent. Is that applicable in Nassau and Suffolk County? No, it's only New York City. Right now, this is only New York City. All right. But if you're a Suffolk County, Nassau County agent and you have a listing for a rental in Queens, this would apply to you. It's based on where the property is located. All right. Enforcement and penalties, pretty significant. It's being enforced by the city. Fines can be up to $1,000 for the first violation, $2,000 for subsequent violations. That's on the collection of fees. 500, 1,000 for failure to provide an itemized disclosure. A tenant can also bring a civil action, meaning they could bring their own lawsuit. You could also run into issues with Department of State, who said that they will be monitoring this, even though it is a local law. And you could obviously be at risk of not being able to collect any commission. So, I see that $1,000, $2,000 penalty. You may say, well, that's not that much. That's just one consequence. Other consequences can be a lawsuit brought against you. You could have license issues, and you would have issues collecting any commission based on the work that you had done. Question I see, is there a special form for this? No, not really. So think about the LIBOR exclusive right to rent agreement already had provided that any fee that would be paid by the owner is paid by the owner and not by the tenant. You want to make sure, again, that any listing agreements you have for rentals in New York City do not say that the tenant will pay the listing broker's fee. We may be adding some it's not required, but some disclosure language to the exclusive right to rent, just to explain to the landlord what the Fair Act is, but that's not required. So really no changes to forms yet. Although we may be making some modifications in the future. There's nothing, no language that's required in terms of disclosures to parties. But make sure you're providing your agency disclosures. Make sure you have a written agreement with your landlord. And if you're working with a tenant as a tenant's agent, you have to have a written agreement. You need to be able to justify what services you're providing to that tenant and why the tenant is paying you a fee for working as a tenant's agent. Couple questions that have come into the Legal Support Center on this. Can the landlord in New York City have the tenant pay the first month's rent to the listing agent? Hopefully this is clear. No, remember, I keep getting back to, you can't accept any fee. So call it whatever you want. The landlord's agent can't accept money from the tenant. So the answer is no on that. Let's see. Does the Fair Act prevent a landlord's agent from accepting a broker fee from a voucher program? It's not clear yet. I'm being honest with you. There's no definitive answer on that. But I will say the law clearly provides that you cannot impose a fee or collect a fee from a tenant, right? So never, ever, ever ask a tenant for a fee or demand that their voucher program pay a fee if you're the landlord's broker. If the program offers to pay the broker fee and they feel they're permitted to do so, make sure that you document the voucher program's position in writing. I think the programs will start to put out some guidance on what their position is. But as of now, there's no clear guidance on this. But I would just say never request it, never demand it, never require it. But if the program does offer it, just make sure that you've documented that offer came from the program, and who at the program offered it. So you'd want to get that in writing. Another question, can I confirm this is residential only, not commercial in New York City? Yes, I can confirm that this is residential only. This does not apply to commercial leases in New York City. And I think this is the last of the Fair Act questions. Does the Fair Act prohibit a tenant's agent from splitting commission received from a tenant with a landlord's agent? Yes. Again, landlord's agent has to be paid by the landlord. In this scenario, really all you're doing is a pass through. It's not allowed. I mentioned that before in terms of commission sharing. So tenant's agent cannot share their commission with the landlord's agent. I will say if you want to check out our website, lirealtor.com /fair, F-A-R-E. We have a short video, a flyer, some resources from New York City that explain a little bit more about this. And as the city clarifies more, we will obviously put more information out to all of you. So please stay tuned. Next update for everybody. This is statewide. The New York State property condition disclosure has been updated. Effective July 1st, there is a new version of the property condition disclosure statement. So June 1st, July 1st. If I said June, I meant July. July 1st, a new version of the property condition disclosure statement is required. So as of July 1st, you're going to want to change and update your forms. Get rid of the old version and start using the new version. It's a very minor change, not really a huge one, but it's a required one. There are new instructions under question 36, which deals with sewage systems. It includes a reference to the State Department of Health website for septic system operation and maintenance. This is it. This is the sum total of the change. It's just a new bullet that's added under question number 36. The question is still the same. It asks the seller if there are any known material defects to their sewage system, and the new form adds this language. It now says, if yes, explain below. More information on septic system operation and maintenance can be found on the New York State Department of Health website, and goes on from there. Again, this is the only change, but it's a required change, so you will need to update your forms. The new form is available on the New York State Department of State website. It's available on LIBOR's documents on demand page. I also know that the One Key will be putting it up on Transaction Desk. It's already been available. Tiffany asked, can this form be used before July 1st? It can. There's no, you would probably want to inform the seller that information isn't necessary, but I really, there's no harm in my mind in using this form before July 1st, okay? So if you want to make the switch now, you can, but it is mandatory starting July 1st. It would apply to active listings without a signed contract of sale after July 1st. If, let's say, your seller already signed a property condition disclosure statement before July 1st, let's say they signed the old one, but they have not, they're not in contract yet, you'd want to have them complete the new form. I know it's a bit of a pain in the neck, but the buyer is entitled to receive the new form after July 1st. Just a reminder, all the other obligations regarding the property condition disclosure statement are unchanged. There's nothing else that changed. Seller has to still complete and sign the property condition disclosure statement. Remember, there's no $500 credit available to buyers. I know you all know that. Unfortunately, there's a lot of attorneys out there who still are putting in contracts the language about a $500 credit. The seller must provide it to the buyer. It has to be provided before the buyer signs a binding contract of sale. The seller may decide to provide it earlier. No issue with that. It probably makes sense to facilitate a deal. If I were a buyer, I'd want it before I do my home inspection because I'd want my inspector to see the statement, right? Buyer has the right to ask for that, but the seller does not have to provide it until the point the buyer signs or just before the buyer signs a contract of sale. So buyer doesn't have a legal right to get it sooner, but they certainly can ask for it. And I think in most cases, it probably makes sense for the seller to provide. Just remember your only obligation, you're not obligated to assist the seller in filling out the form. It's a legal document. Your obligation is to inform both sellers and buyers of their rights and obligations under the law, period. That is your obligation. If you have other questions about the property condition disclosure statement, go to our website again, lirealtor.com/PCDS. There's a wealth of information there about the process for how it can be, how it needs to be provided, how it needs to be explained, etc. Next update I want to let you all know about is the Code of Ethics is changing, or it has changed. There's been an update to the National Association Realtors Code of Ethics. The big change is Standard of Practice 10-5. So NAR, which is the National Association of Realtors, which if you're a member of LIBOR, you're all members of the National Association of Realtors. They updated Standard of Practice 10-5 due to language that was being construed too broadly, and there was a possibility of it not being enforced consistently. They also updated policy statement 29, which clarifies the Code of Ethics no longer applies to all of a member's activities. They've changed that language. I'm going to go through the two changes here. And then lastly, they updated the Code of Ethics to make changes related to the NAR settlement. Basically, it removed any rules or requirements related to mandatory offers of compensation on the MLS. I'm not going to go through each one of those in detail. They're pretty self-explanatory, but you have to now let all sellers and buyers know compensation is fully negotiable, not set by law. You should all be doing that already because it's required to be in all of your forms. So that was the other change that was made. But the one I'm going to focus principally on right now is just the change to 10-5. I see some questions, just to back up for a second, about the property condition disclosure statement. Yes, Tiffany, thank you. You've answered both questions in the chat. Tiffany's not my assistant. But she answered both correctly. The PCDS is for residential sales only. It's not commercial sales. It's not for rentals. And co-ops are exempt. There are other exemptions to the property condition disclosure statement. Again, if you've got questions about the property condition disclosure statement, please go to our website. All of that is there. I was just really giving you an update on the change in the form. But if you need a primer on the entirety of the property condition disclosure statement, please go to the website. No, and Tiffany, no need to apologize. I just wanted to make sure people knew they could rely on your responses. Tiffany I appreciate, I don't think she was trying to step on my toes. I'm glad she answered it. I just wanted everybody to know that her answers were correct. So thank you, Tiffany. So we're going to now move on to just back to 10-5. So what is 10-5 for those of you that don't know? Well, it's a standard of practice in the Code of Ethics under Article 10. So every article in the Code of Ethics, there's 17 of them, they all have standards of practice. Article 10 just generally prohibits discrimination in professional services and employment. Back in 2020, NAR introduced a new standard of practice 10-5. And that addressed hate speech, slurs, and harassment based on any protected class. And when they introduced that, they also made a change to policy statement 29, which said the Code of Ethics applies to all of a realtor's activities. So effectively, 10-5 outlawed hate speech, slurs, harassment in all of a realtor's activities, whether or not they relate to real estate or not. So what happened this June? NAR amended Standard of Practice 10-5. These show you the changes that were made, but basically it now reads that realtors in their capacity as real estate professionals in association with their real estate business or in their real estate activity shall not harass any person or persons based on protected characteristics. So now it's just limited to harassment. And it also, the limitation is in your capacity as a real estate professional or in association with your real estate related activities. There's also been I guess, a definition now for harassment that's been provided. Policy statement 29, I mentioned, was also changed. So you see it had applied the code of ethics to all of your activities, regardless of whether they related to real estate. Now the code only applies in your capacity as real estate professionals in association with your real estate business or in your real estate related activities. This all goes into effect immediately. So I see, and Belinda, good question. Belinda's asking about, does this change mean on social media that someone can post something that qualifies, as harassment, and they kind of can get away with it under the code of ethics because it's not related to their real estate? Well, it depends. So remember, now it only applies to real estate related activities, right? But your real estate related activities include advertising, right? And that covers a wide range of activities. So, it's going to be on a case by case basis. But if somebody is using their social media page to advertise that they're a realtor and they're putting their listings on there, and they then engage in harassing behavior based on a protected characteristic, using that social media page, using that advertising vehicle, that can still trigger 10-5. So just realize it's not, I think this is more of a clarification. I don't think that this provides a license for members to go out and harass people when they're, off the clock. If you're going to use your social media page for real estate related activity, that page shouldn't be used for harassing others based on protected characteristics. Also, I just want to point out that LIBOR's bylaws have the following language. This is a duty of membership. This is separate and apart from your duty under the Code of Ethics, but every realtor member shall maintain a high level of integrity and adhere to the association's membership criteria. Any violent act or threat of violence to person or property, hateful conduct, or acts of moral turpitude impacting the public shall not be tolerated and may be cause for disciplinary action up to and including termination of membership. So all of our members still have a duty to uphold this duty of membership. So, even though the Code of Ethics may have been clarified, I think the fact that this remains in LIBOR's bylaws is a strong message and something that all our members have to uphold. So I don't think the standards have necessarily been lowered. I think they've just been clarified. So if you've got more questions about this, we've got a lot more on our website. NAR's put out more. And they're also going to be putting out some what are called case interpretations that I think explain this in a little bit more detail about what is real estate related activity when it comes to using your social media account. A couple more topics. I would like to cover quickly lawful source of income discrimination. And I've been covering this in legal updates for the last couple of years. And the reason being is that it is still probably the most significant area of undercover testing in our industry. And it's also an issue where we're continuing to see property owners and real estate licensees not understand the law. There have been continued instances of testing showing violations. So until we see that it's no longer a pattern, it's something that I personally am going to provide education on. So just really, really quick, lawful source of income is a protected class in New York State. It's also protected at the local level, but under the state law, throughout New York State, lawful source of income is a protected class. It's no different than race, religion, gender. It is a protected class. So that means I, as a housing provider, I can ask you what your income is. I can say, where do you get your income from? That's fine. I could say, give me documentation of your income. That's fine too. I want to know, do you have the ability to pay for a housing accommodation? But I have to accept all lawful sources of income equally. That means I can't say I like somebody here because they get their income from a job versus somebody who gets it from some other source, like Social Security, like a voucher. If they have the income to afford the apartment, I have to treat those incomes equally, period. That's what the law says. Lawful source of income means a lot of things. It's really any legal means of receiving income. A landlord has to consider all of it and can't pick and choose and say, I like one source better than another. The big area we see source of income violations or problems comes with vouchers or public assistance. And you cannot discriminate, a landlord cannot discriminate when using a broker based on lawful source of income. So I mentioned a lot of issues, a lot of undercover testing. Since 2020, this one group, Long Island Housing Services, which is a not-for-profit that does testing, they're not looking, and I will say all the state agencies, they're not looking to get real estate licensees in trouble. They're looking to make sure that tenants who have vouchers have the opportunity to be considered for an apartment. That's what they want. And just since 2020, they've had to settle 34 complaints related to source of income discrimination. That's just one organization. I can tell you that at the New York City level, the New York State level, lawful source of income complaints are the number one with disability related complaints that continue to come in. And these are just a couple reports from the last 2 years of cases where testers are saying, hey, landlord doesn't participate in the programs, or we don't have any room for people. We've reached our quota for people that have housing subsidies. That's all discrimination. A landlord cannot do that. So what is that? What else does source of income discrimination look like? It's not responding to inquiries. It's ghosting people. It's telling voucher holders you don't work with them. I'll have to get back to you. I need to find out if the owner will take a voucher. The owner has to take a voucher, period. Certainly, if the voucher doesn't pay the rent, that's a different story. That person might not have the income sufficient to afford that apartment. But landlords have to accept vouchers just like any other income. So what do you do? What should your process be in order to make sure that you're not discriminating? Well, never turn away a prospect because they receive financial assistance. Have the same process for every tenant, regardless of where they have their income come from, right? You don't treat purple tenants different than green tenants, right? You don't treat tenants that are one religion different than another. You have the same questions for all of them. You have those same questions for people who have a voucher. You're going to tell people about all the vacancies that meet their needs, regardless of where they get their income from. You follow standard procedures for all prospects. So every prospect that calls up, no matter where they get their income from, ask them where they're looking. Ask them how many bedrooms they're looking for. Ask them what their price range is. That's it. Show voucher holders the same apartments you would any other prospective tenant, regardless of their source of income. If someone does say, well, I have a voucher, okay, great. Can you send me a copy of the voucher? Let me get the name of your caseworker. Educate yourself to the details of the program. And I will tell you that the experience with many landlords and most landlords when dealing with voucher programs is positive. it winds up being a guaranteed on-time payment from the tenant. There's no issues. It's not, oh, I forgot to put the check in the mail, or I changed my bank account. They have years of stability and guaranteed payments when it comes to the rent. So what do you do though if you have an owner who says, I'm just not accepting vouchers or subsidies? You as a real estate licensee can't work with that person. So never under any circumstances abide by a property owner's instruction to refuse to rent to any tenant seeking any kind of assistance. You have to tell them that you can't follow their directive. And if they say, well, that's not good enough for me, well, then you have to stop working with that owner, that landlord. Document the termination of your relationship. You have to tell them, look, source of income discrimination is treated like any other discrimination. And I will say that when it comes to real estate licensees, if Department of State finds that you have engaged in source of income discrimination, they're not just looking to fine you. They will look to suspend or terminate your license. I've heard that directly from Department of State. So please make sure that you're taking this seriously. This question comes up a lot. So can a landlord require a credit check or a certain credit score for voucher holders? If the voucher covers 100% of the rent, no, that's it. The government's saying we're guaranteeing, we're paying this tenant's rent. Looking at their credit score is completely irrelevant. That would constitute discrimination. You've put up a barrier to prevent someone who's got a guaranteed payment for 100% of the rent. What if the voucher only covers a portion of the rent? Legally, credit can be considered on a case-by-case basis, but requiring some kind of minimum credit score may still violate the source of income laws. And it may trigger an investigation by the state or the city. Why? Well, a credit score might not be a valid indicator of the ability of someone with a partial subsidy to pay the rent. They're probably getting that subsidy because they have limited credit. Because they have no credit history. Very often voucher holders don't have credit. So if you require, a landlord requires a credit score for somebody that just has to make up 20% of the rent, that's going to have an effect of excluding all voucher holders. And remember, these programs, they do a full-fledged analysis to determine what portion of the rent a tenant can afford to pay. So they've done that work. So for the landlord to then try to do something else and put a barrier up, a landlord has to be very careful in that circumstance of applying a credit score. I'll answer. I'm going to just move on. I know there's some other questions here about source of income. If you could save those to the end. I just want to get to the last couple topics, and we only have a couple more minutes. I do like to just provide everyone a reminder about advertising. Reason why is it's always top of mind with Department of State. If you are ever brought before the Department of State for any alleged violation, they will look at your advertising, period. They will look at your email signature, your website, your business cards. It is something that is always top of mind for Department of State. So the two handouts that came with the class invite, I provide you with the guidance that Department of State puts on their website, and it's actually the checklist that they use to review advertising. Do your own advertising audit. Do it every 6 months. Pull out all your advertising and make sure you're in compliance. If you do it, you're saving yourself thousands of dollars in potential fines. And believe it or not, Department of State does fine people every month, thousands and thousands of dollars for not advertising properly. And it may sound nitpicky, but it's the law. And doing it the right way makes you look more professional. It makes you look like you actually have a license. And that's the whole point of these requirements. It's for the public to assure they're dealing with a licensed professional by the state. So make sure you're displaying your license title correctly. I'm amazed at the number of licensees that I get emails from that don't have their license title correct. They tell me they're a licensed agent or a licensed realtor. No, you are a real estate salesperson or a licensed real estate salesperson. Go and look at what's on your license, and that's what you need to use in your advertising. That's what you're required to use. Make sure you're not using corporate titles unless you're the broker of record. I don't care if you work in the commercial arena and your firm's made you the vice president of blah, blah, blah. You can't do that. It's illegal to use corporate titles unless you're the broker of record. Associate brokers, salespersons, you can't advertise yourself as a corporate officer. Make sure the name of your brokerage and either the office address or phone number are listed. Big issue I see out there. Teams, you're not your own brokerage, right? Teams are under the broker. They have to advertise the name of the brokerage. What do they say at the very beginning? Who owns the listing? The broker, right? Teams don't own listings. Brokers own listings. And they must advertise under the name of the broker. And if brokers have teams that aren't doing that right, guess who's also going to be held responsible? Not just the team, but the broker. The broker has to be identified. You can use nicknames, but make sure that your full license name also appears. Okay. Please, really easy. I see. Are you allowed to say realtor? Yes, if you are a member of LIBOR, you can use realtor, but that is not a substitute. So you can say, you can say, Jane Smith, realtor, but under that, you have to say real estate salesperson, real estate broker, associate real estate broker. You must include your license. Being a realtor is not your license title. So realtor needs to be used in addition to your license title. This applies social media too. That's considered advertising. Another point I just want to get to, and before I move on to what's going to be my last topic, is be careful with copyright infringement. AI, right? We're all familiar with AI. There are companies that are using AI to scan the internet and find photos that belong to copyright holders, people who took the picture, people who own the rights to that picture. So if you have right-clicked on something you saw on the internet, copied it, and used it on your website, you're engaging in copyright infringement. You cannot use photos that you did not take or do not have a written license to publish and display. And I think as AI grows, there's going to be a lot more copyright infringement cases. So please make sure that you have written permission to use any photos you're using in any advertising, whether it's social media, your website, your listings, unless you've taken the picture or have written permission from the party who owns the rights to it, you can't use it. And you're putting yourself at risk of copyright infringement. Lastly, I just want to cover, this is a warning. Please watch out for some scams that are out there. I just got an email yesterday about this one, and I would say I get them routinely. These vacant land sale scams continue to rise. There are people out there impersonating the owners of vacant land and trying to get you to take their listing. They're contacting you through email, phone call, text message. They've done their homework. They research who the owner of the property is. And you kind of get lured into the idea, well, yeah, they're not here because it's a vacant property. It's just land. No one lives there. So it makes sense that someone's just calling me, right? And you run off and you take the listing. We've had one property get listed 4 times by 4 different brokers, and none of the instances were actually the actual owner who signed the listing agreement. These scammers are trying to trick you. They want to try to get money to sell a property that is not there. So what's the number one thing you can do? If you get a call about vacant land, before you take that listing, before you send out that listing agreement, demand an in-person or Zoom meeting. Get the person visually in front of you. All right. Most of these scammers will not agree to do that. Number one thing you can do. But then do your homework. Ask for multiple forms of identification. Independently search the internet. Check public records. Just do a little bit of homework. Slow down. Don't be in such a rush to take that listing. You are putting yourself at risk. We've had ethics complaints. I know of license complaints brought to the Department of State for listing brokers who have listed a property that they had no right to list. It can just open up a host of issues. Please slow down. But number one thing, vacant land, ask for an in-person or Zoom meeting. Get that person in front of you face to face, and that will help ensure that you are dealing with the actual owner. Last scam I just want to bring everyone up to date on is there's this cryptocurrency scam that's floating around out there. NAR has warned us that there are scammers who are posing as wealthy individuals who are trying to then list properties and develop relationships with realtors. It's called a pig butchering scam. Basically, they're trying to fatten you up before you take the bait, right? What they do is they develop a relationship with you. They pose that they've made all their money through cryptocurrency. They try to get you to invest some money with them, maybe a small amount, because you're not going to believe them. And you actually make money. You withdraw a profit. Maybe it's twice. Okay, well, I'll invest $100 or $500, and you get an immediate turnaround. And you're like, wow, this really seems legitimate, all through cryptocurrency. Well, once you believe it's legitimate, you make a larger investment. Unfortunately, there's been reports nationally that some realtors have even invested their retirement savings. And then once that big investment goes in, guess what happens? Platform disappears, scammer disappears, the money disappears. So I know it sounds, oh, I would never fall for this. Unfortunately, there have been people that have fallen for it. So, you're in a relationship-driven business, right? You have some very clever people out there who are trying to pose as people who want to develop a relationship with you. And the fact that they are actually putting money out there and initially putting money in your pocket, I think lures people in. So please avoid unsolicited investment messages. Be cautious. Watch for any of these types of red flags: urgency, secrecy, people who don't want to get in front of you face to face, anything like that. Do your homework, and number one thing I will tell you in all of these things, slow down. Don't click on emails, without reading them and really making sure they're legitimate. Just slow down. I know it's a fast-paced world that we live in, and you're in a fast-paced industry, but the number one thing you can do is slow down, please. Okay. All right. That is it